Hi, Attorney Jay Farrow here, and this segment is remedies for breach of oral agreements. Going back to what I said on the previous segment about contracts and being verbal or not, have the same components. So you have an offer, you have acceptance, you have some type of consideration that's being exchanged between the parties, and then you have performance. Well, if one party enters into a contract and they don't perform, whether it's verbal or written, but let's sticking with the verbal context of this segment, you can file a lawsuit in Florida for breach of oral agreement. Now, what are the remedies? Well, just like with the written contracts, you have the remedy of whatever consequential damages that resulted. So if you paid for a TV and that TV was never delivered to you, well, you can ask the court for the amount of money that you actually paid for the TV. That's compensatory damages. Now, there's also a remedy called specific performance, and it is exactly what it sounds. You can actually ask a court to have the other party perform under the contract. Now, courts don't like getting involved. The courts like giving people money for damages. They don't really want to be in the business so much of telling somebody that they have to do something. But in certain contracts, certain agreements, specific performance is going to be required by the court. Now, there's other things that you can do with regards to a contract. You could ask for some type of injunctive relief, something up front to say to the court, look, this is what our agreement was. There's no question about it. There's no question about the fact that I gave some money to the other side and we have consideration, but this person's about to do something with the property that belongs to me that I paid for, and I'm going to ask the court to enjoin, to hold that property in a storage place or something like that until we can resolve this thing. So you have a lot of avenues, there's a lot of remedies that are available to you under a verbal contract, but I'm going to give you a warning for all of you out there that think that you're going to run your life only on verbal contracts. The most important thing in a contract, or one of the most important things, as far as the law is concerned, logistically, is what's called a prevailing party attorney fee provision. What is that? That means that if there's ever a breach of the contract and somebody has to sue to enforce their rights, the prevailing party in the action would actually get their attorney's fees. So most attorneys bill by the hour or they bill by a flat fee, but either way, you have to pay your attorneys to file a lawsuit. Well, you want to be able to recover that money, and the law says, yes, you can, as long as you put into the written contract a single sentence saying that the prevailing party at the end of all of this would receive their attorney's fees. Now, in a verbal contract, you're not going to have that. And you'd have to actually verbally agree, and that have to be proved by testimonial evidence or the like. But in most cases, verbal contracts never have that prevailing party attorney fee provision because people aren't really thinking about that when they're entering into a verbal agreement as opposed to a written agreement. So if you want to continue to, see whatever happens and enter these verbal agreements, absolutely you could file a lawsuit to get your money or maybe get the property or have the other person perform, but it's not advisable to run your life on just the verbal agreements. So I hope you got something out of today, and thank you very much, and check out some of our other videos.